Ready? Start. In the counter affidavit filed by the CCI, it was explained that there was an overwhelming response received from the candidates for selection to the aforesaid post, and having regard to the large number of applications received, the CCI decided to undertake the selection to all posts notified in the advertisement on the basis of written test followed by interview, and accordingly it was determined that written test would be for 80 marks while 20 marks were attributed to interview. Further, candidates who secured minimum of 50 marks in the written test in the general category and minimum of 40 marks in the reserved category were called for interview in the ratio of 3 times of the number of vacancies, where the number of vacancies were more than 10, and 5 times of the number of the vacancies for less than the 10. The marks obtained in the written test were not disclosed to the interview committee, and the committee independently and without being influenced by the marks obtained in the written test adjudged the candidates on the basis of viva voce test and awarded the marks. The marks of the written test, which were kept in the sealed cover, were opened after the marks given to candidates in the interview by the interview board, and tabulated merit list was prepared accordingly. The CCI, keeping in view the nature and purpose of the post, decided to fix the percentage for final selection were 70 marks out of 100 for unreserved category and minimum 65 marks out of 100 for reserved category for professional categories, in which category the post of deputy director law falls. It was argued that such a course of action was permissible, and it was not a case where the mode of selection at any time was changed, and in so far as fixation of benchmark is concerned, that was prerogative of the employer. The learned single judge of the High Court accepted the plea of the respondents, as he did not perceive this to be the change in criteria in the selection procedure, holding that fixation of the benchmark was legal and justified. In the aforesaid backdrop, the question that falls for consideration is as to whether fixation of benchmark would amount to change in the criteria of selection in the midstream when there was no such stipulation. The learned senior counsel, appearing for one of the appellants, submitted that the case is squarely covered by the ratio of judgment of this court in Himani Malhotra versus High Court of Delhi. That case pertained to recruitment to the higher judicial service in Delhi. The mode of selection was written test and viva voce. 250 marks were assigned for written test and 750 marks prescribed for viva voce test. When the advertisement was given, there was no stipulation prescribing minimum marks, cutoff marks at viva voce test after the written test was held. The persons who qualified the written test were called for interview. Interview was, however, postponed by the interview committee, and it felt that it was desirable to prescribe minimum marks for the viva voce test as well. The matter was placed before the full court, and full court resolved to fix minimum qualifying marks in viva voce, which were 55% for general category, 50% for SC/ST candidates. After this change was affected in the criteria, thereby prescribing fixation of minimum qualifying marks, the interviews were held. The petitioners in that case were not selected as they secured less than 55% marks. Those two petitioners filed the writ petition submitting that prescribing minimum cutoff marks in the viva voce test after the selection process had started, when there was no such stipulation at the time of initiation of recruitment process, was unwarranted and impermissible. The court, taking notice of its earlier judgments in Leeladhar versus State of Rajasthan, held that when the previous procedure prescribing minimum marks was not permissible at all after the written test was conducted, The ratio of the case is summed up in paragraph 15 of the judgment, as there is no manner of doubt that the authority making rules regarding regulating the selection can prescribe by rules the minimum marks both for written examination and viva voce. But if minimum marks are not prescribed for viva voce before the commencement of selection process, the authority concerned cannot either during the selection process or after the selection process add an additional requirement qualification that the candidate should also secure minimum marks in the interview. Therefore, this court is of the opinion that prescription of minimum marks by the respondent at viva voce test was illegal. This very argument, based on the aforesaid judgment, was taken in the LPAs before the High Court as well. However, the High Court took the view that the aforesaid judgment was not applicable in the instant case, as the factual scenario was altogether different in this particular case. Stop.